Hello everyone, my name is Gaston Kroub with Markman Advisors, and we're here with this week's Markman Minute. You can catch all of our content at mimesislaw.com under the Intellectual Property tab, together with all the other great content put out by Mimesis, so please be sure to check it out. For this week's discussion, I wanted to talk about some of the biggest news in the patent space that came through last week at the tail end of the week, which was the decision by the Patent Trial and Appeal Board of the United States Patent and Trademark Office to allow Kyle Bass's various petitions that were filed against Celgene for inter-parties review to try to invalidate Celgene's patents to proceed. And basically the procedural posture of the case was Celgene had asked the Patent Trial and Appeal Board to dismiss the IPRs on the basis that they were an abusive process and that Bass had engaged in sanctionable conduct for a number of reasons. One, because of his core strategy of filing IPRs against pharmaceutical companies in order to invalidate the patents and short the stock of those companies as a result of any decline in value because of the loss of any patent protection. And two, Celgene had argued that one of Bass's compatriots had actually solicited a pre-filing settlement from Celgene prior to filing the petition. And in Celgene's mind, that was a basis for sanctions and further proof that Bass was abusing the IPR process in a way that warranted dismissing the petition as a sanction. So the Patent Trial and Appeal Board panel, and this was an expanded panel of 6 judges as opposed to three judges, which is the normal cohort of judges in an IPR process. The panel of 6 judges took a look at the sanctions motion and came out quite firmly and said that there's nothing sanctionable here, which means that the patent, that the various IPRs that were subject to these sanctions motions are now going to proceed to the next level, which is the substantive review as part of the institution process. Now, generally, it's well known at this point that Bass and his IPRs have yet to be instituted on the merits. But this was an important incremental decision since the business strategy, so to speak, was under review by the Patent Trial and Appeal Board as a result of Celgene's sanctions motion. And it's important to realize what the PTAB ruled, what they decided, and what they decided to ignore, as with anything in life. So what did they decide? First of all, they decided that there was nothing wrong with Bass using the IPR process, even though he was a short seller. And as part of that analysis, they focused on 3 issues. One was whether or not it was an abusive process because Bass had a profit motive in filing his IPR. Second, they looked to see whether or not there was an abuse in the process of using an IPR because Bass did not have what was called a competitive interest in invalidating the patents. And then third, more generally, they looked at whether or not Bass his IPRs were filed for an improper purpose, just based on the whole general strategy and the supposedly sanctionable conduct that his compatriots had engaged in pre-filing. And let's focus on what they actually decided. So first of all, the PTAB decided that with respect to the profit motive question, it wasn't their job to decide whether or not short selling was legal, beneficial to the economy or not. They simply said everybody that files a IPR or engages in the patent system because a patent is an economic right has some kind of profit motive. And as a result, that's not a reason to get rid of Bass's petitions wholesale. And with respect to competitive interest, again, the PTAB panel refused to limit IPRs, even IPRs against pharma or biotech companies, to generics or other companies that could clearly demonstrate a competitive interest in validating patents. According to the PTAB, Congress made IPRs available to any third party, and there was no general need to limit IPRs to only those parties that had a competitive interest. Here again, the PTAB didn't want to get into a decision of what's a competitor and what's a valid competitive interest or not. IPRs are available to third parties, so anyone can file them subject to the other rules such as time bar and the other restrictions in the statute. And then with respect to the more global abuse of process question, the PTAB came out very strongly and said, look, IPRs are not only there as a mechanism for companies that are in litigation to get out of those litigations in a more streamlined way, which was one of the arguments that Celgene made about the purpose of IPRs in the first place. IPRs are really available to improve the patent system as a whole. And in so doing, they confirm the public interest in getting rid of bad patents, which is exactly the argument that Bass has been making publicly, which is that these patents are bad patents, never should have issued in the first place, and are being used by the drug companies to help prop up monopoly pricing on drugs, including Celgene's drug, Revlimid, which contributes a large portion of Celgene's revenue, and is a super high-priced drug. I remember reading a few months ago an op-ed by Tom Brokaw, the former NBC News anchorman, who was talking about his own treatment for multiple myeloma, I believe. And he mentioned he was shocked at the cost of Revlimid to the point where, while it may have been comfortable for him to pay for that drug, and he clearly appreciated the benefits that it gave him from being treated with it, he couldn't understand how normal Americans would be able to afford the price. So the issue of drug pricing, as we've mentioned, is becoming more and more of an issue. It's becoming more politicized, and Bass is playing his role. What's clear is that the PTAB has decided they're not going to pass judgment on whether or not he's using the IPR system for an improper purpose, but what they are going to do is they're going to look at each one of his petitions on the merits. So that's what we're looking for next. We're looking to see, A, whether or not this decision carries through to all the other IPRs that Bass filed, where the other pharma companies like Celgene argued that his patents were an abusive process, his petitions were abusive process. And if so, would all of those petitions proceed to judgment on merits? And then more importantly, we're going to look to see whether or not Bass can actually break the ice and get one of his IPR petitions instituted on the merits. That's it for this week's Markman Minute. Again, I'm Gaston Kroub from Markman Advisors. You can check out our content at mimesislaw.com. I'm talking about a recently announced global settlement between Microsoft and Google with respect to all pending patent litigation in the United States and in Germany between the two companies. And some of the cases that they've been involved in are very interesting ones, including some that we've covered here in the past.